All right, guys, we're going to go ahead and get started. You have entered into the webinar for Estate Planning Basics. My name is John Sagraves. I'm a senior advisor here with Wright-Patt Credit Union and Coosa Financial Services. Been with the credit union for about 9 years or so, been in the industry for, I guess, about 17 or, give or take. But I want to emphasize that this is Estate Planning Basics. In this presentation, we're going to take a look at some general estate planning concepts and strategies. And while there's no such thing as a one-size-fits-all estate plan, this overview, I hope, will assist you in thinking about your own estate planning needs and may help you in determining whether or not you might benefit from working with a financial planning professional. So we're going to jump right in, get some disclosures out of the way here. So what is an estate plan? I imagine that you're attending this presentation basically to accomplish at least one of the following. You want to either provide a legacy or estate or protect your legacy or estate. And so to accomplish this, you need an estate plan, which is simply a map of how you want your personal and financial affairs to be handled in case of incapacity or death, okay, and the subsequent implementation of the strategies that will fulfill those objectives. Who needs an estate plan? Chances are you do, okay? You may think that estate planning is just for the wealthy, but it's not. In fact, an estate plan may actually be more important if you have a smaller estate because your final expenses will have a much greater impact on your estate, and there's a much greater possibility that your loved ones could suffer from a lack of financial resources. So the fact is that without an estate plan, you can't control what happens to your property if you die or become incapacitated. And generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid family disputes. And in addition, they care about preserving their property and their loved ones for their loved ones, and want to make sure that their loved ones are properly provided for. So an estate plan is especially important if your spouse isn't comfortable with financial matters. It seems like in my line of work, there's always what I call the CFO of the household. There's typically one person that kind of handles the financial affairs, and in many cases, that leaves the other party or the other spouse, not intentionally, but sort of in the dark about things and how to access, finances and where everything's positioned and that type of thing. So, if your spouse isn't comfortable with those financial matters, then that's why an estate plan really is important. If you have young children who would need a guardian, then an estate plan would be especially important. If you have an estate that would be impacted by transfer taxes, so in 2021 on the federal level, that generally means estates that are over $11,700,000. And we'll go into more detail about that later. Also be aware that this amount may be lower on the state level, and states impose their own transfer taxes, and each state has a different exemption amount. Estate planning is also particularly important if you own property in more than one state. If you have privacy concerns, an estate plan would be important. If you have other distinct needs, for example, planning for the succession of a business, or if you have special needs, children or grandchildren, that type of thing, then an estate plan would be especially important as well. Okay. Some basic estate planning concepts. These are the concepts we're going to be looking at today. We're going to be talking about planning for incapacity, Then we're going to be discussing both healthcare issues and property management issues. We're going to talk about planning for death and focusing on wills and probate, tax basics, um, lifetime gifting, trust, and the role of life insurance in estate planning. Okay, so these are some of the things we're going to talk about today. So planning for incapacity. Incapacity basically just describes a condition in which you are legally unable to make your own decisions. And we're talking about that first because, quite honestly, that can happen to anyone at any time. And think for a moment about what might happen if, for example, you were to become victim of an accident that puts you in a coma for several months. You know, how would your doctor know what medical treatments you would want or not want if you can't speak for yourself? How would your business, your personal business, be transacted if no one's authorized to sign documents for you? Okay. So basically, what would happen is this: someone would have to go to court and get legal permission to do things for you. Okay. And that person, who's called a guardian, is usually a close family member, such as a spouse or child, but they would have to go back to court every time permission is needed for something new. So as you can imagine, you know, this would be quite burdensome and time consuming to the guardian. Further, without any prepared instructions from you, the guardian might end up making decisions that would be different from what you would want for yourself or what you would have decided. Okay. So, you know, again, that's why having an estate plan is important. So planning for incapacity, there's a few things that you want to take into consideration, and we're going to talk about different healthcare directives. You can leave instructions about the medical care that you would want if conditions were such that you couldn't express your own wishes, okay? And there's basically three different ways to do this. A living will, a durable power of attorney for health care, which is also referred to as a healthcare proxy in some states, and a DNR, or a do not resuscitate order, okay? So first, a living will is basically a document that lists the types of medical treatment you want or do not want under particular circumstances. So for example, your living will might state that you would not want life support if you fell into a persistent vegetative state. And so with a living will, you'll have to think about all the possible scenarios where you would want a specific action to be taken, and then you put your wishes in writing so that the reader would clearly understand them, okay? A durable power of attorney for healthcare or a healthcare proxy lets one or more family members or other trusted individuals make medical decisions for you, okay? Unlike a living will, with this type of healthcare directive, you don't have to envision specific circumstances. You simply grant authority to your agent or agents to make decisions for you. So I'm going to back up. A living will is where you're making those decisions in advance and really gives you the most control. A healthcare proxy is where you're basically transferring that control over to, you know, another individual. And then a do not resuscitate order is used for a little bit different purpose. Let's say that you're in a hospital, you know, lingering and suffering with a terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly go into cardiac or respiratory arrest. So to make sure your wishes are carried out, you may be able to get your doctor to issue a DNR, which is a legal form signed by both you and your doctor that's posted by your bed to give staff members the permission they need to carry out your wishes, okay? Now, with a DNR, you've got to be careful because some states require their own DNR forms, and some states require one DNR form if you're in the hospital and a different DNR form if you're in a nursing home, okay? So, you know, just kind of keep that in mind. So there, it's a little bit more questionable about who's in control of your wishes, right, at that point. Also be aware that in some states, don't recognize some of these healthcare directives. So depending upon your state, you might need one, two, or all three of them, okay? Now we're going to take a look at what's referred to here as property management tools, and I'm going to kind of simplify that and call it account titling. Okay, so if you're talking about financial property or financial accounts, this is really about different forms of titling. Okay. There's basically three ways that you can plan to have your financial affairs taken care of for you in the event you become incapacitated. You can arrange to own property jointly, appoint an agent using a durable power of attorney, or create or put property in a living trust and then name someone to take over the management of the trust if something happens to you. Okay, so that person, whoever is managing the trust at that time, is referred to as the trustee. So granting joint ownership, we'll talk about that first, of your property to another person is probably the easiest thing to do. It allows that person to have the same access to the property as you do. So if you become incapacitated, the joint owner simply acts instead. So for example, if you and your spouse have a joint checking account, each of you can make deposits, you can write checks. So if you were in a coma, your spouse, would still be able to make the mortgage payments on time. They have authorization to, write checks and make withdrawals from those joint accounts. So with that being the case, obviously, because whoever is joint owner on your account, you want to make sure that you fully trust them, right? Because they can be making withdrawals on your behalf while you're still living. And hopefully they're doing that under the best intentions. But we all know that sometimes people take advantage. And so you just want to make sure that whoever you are putting as joint owners on your accounts, that you have, full trust with them and what their intentions are. Okay. A durable power of attorney basically lets you name family members or some other trusted individual to make financial decisions or transact business on your behalf. So just like the durable power of attorney for healthcare. So even though they're not joint owners on the account, they can still authorize transactions and things of that nature. They're just doing it under the title of a power of attorney. Okay. Now, in addition to joint ownership and durable power of attorney, using a living trust is another common strategy, and we'll talk in more detail about trust later. But for now, just know that a living trust can be used in planning for incapacity because someone, again, a trustee, can step into your shoes to manage the property in the trust if something should happen to you. Okay. Now, what if all of your assets, or the majority of your assets, are held in retirement accounts like IRAs and 401ks, thrift savings plan, 403bs, things of that nature? Okay. Well, you can't put joint owners on retirement accounts. Also, generally speaking, you cannot put retirement accounts in a trust. And so in order for someone to have access to retirement accounts, really using a durable power of attorney is the only means of access to those types of accounts. Okay, so that's just something to keep in mind. So what happens if you die without an estate plan? Okay. If you own property jointly, that property may pass automatically to your joint owner upon your death. And if you have an IRA or retirement plan, or you own life insurance, funds may pass automatically to your designated beneficiaries when you die. And um, listing beneficiaries, quite honestly, is the easiest, one of the most effective things you can do, is just make sure that all the beneficiaries on your various accounts, retirement accounts, life insurance, even checking, savings, money markets, brokerage accounts, whatever the case is, that you're putting on beneficiaries, or maybe called payable on death, PODs, or transfer on death, TODs. You just want to make sure your beneficiaries are up to date on your, various financial accounts. Okay. Also, property held in a trust, would pass automatically to the designated beneficiary. Um, However, if you do not have an estate plan, the state that you live in has one for you. And that's basically where property will pass according to state intestacy laws. So these laws govern the disposition of property when someone dies without a will, or with a will that doesn't account for a portion of his or her estate. Okay, so like I said, if you don't have an estate plan, the state has one for you. Okay, and so what that might look like is, let's say you die leaving $5,000 in a savings account. Who does the money go to? Okay, well, without instructions from you, the money would go to the person or people that the state intestacy laws say it should go to. So intestacy laws vary from state to state. And so here you see a typical pattern of distribution where 50% of the property goes to the spouse and 50% of the property goes to the children. Okay. Now, remember, that could be different in your state. And since I'm in Ohio, and a lot of our members, the majority of our members are in Ohio, Ohio is different. So in Ohio, 100% of the assets would go to a spouse, and none of the assets would go to the children. Okay. So again, you just got to make sure you understand what the state laws are for the particular state that you reside. The biggest issue with intestacy is the fact that your actual wishes are irrelevant. Okay. And this is where you start losing control, because it's state controlled. Okay. So let's assume you live in a state that has intestacy laws pattern as shown on the slide. And without an estate plan, regardless of your actual wishes, your estate's going to be divided up between your spouse and your children. Okay. So, again, in Ohio, it's all going to go to your spouse. But if you wanted part of it to go to your children, the state's not going to allow that. Okay. So again, you begin losing controls when you rely on the state's intestacy laws. So there's many problems, with allowing your property to pass by intestacy. For example, the distribution pattern imposed by your state laws could result in disputes among heirs, or higher overall taxes that could be due. Intestacy can be particularly problematic for unmarried couples, since intestacy laws generally will not include an unmarried partner in the distribution of property. And quite honestly, there's a very simple way to avoid intestacy, and that's really just by getting a will created. Okay. And so we're going to jump over to wills and probate. And a will is simply, it's probably the most vital piece of anyone's estate plan. A will is a legal document in which you direct, again, you control how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for minor children, and you can also create a trust in your will. Okay, so again, you are controlling what is happening through or happening to your estate through the use of a will. And so, that idea of you controlling things is really going to be the main theme, throughout this presentation. You can also use your will to accomplish other estate planning goals as well, such as tax planning. But to be valid, your will must be in writing and signed by you, and your signature must also be witnessed. Okay. These requirements are important because if you aren't careful, your will may be invalid. So, I would say see an estate planning attorney to take care of this for you, and maybe avoid any of the do-it-yourself solutions. I mean, you can look at Quicken Willmaker or LegalZoom, things of that nature. And you might say, you're going to save a few bucks by using those services, but I think you also want to make sure that, you're working with an estate planning attorney for whatever state that you're in. You want to make sure this stuff is done correctly. Okay. Now, there is one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate. And we're going to take a look at that process next, okay? So most wills have to be probated. And, what does that idea of probate consist of? Probate basically starts with someone filing the will with the probate court, which will then oversee the estate settlement process. Okay. Now, usually the person named as the executor in the will handle that. And once the will is filed with the court and validated, the executor can basically begin settling the estate. Now, what you've got to keep in mind is just because you list in your will that you want Johnny to be the executor of the estate, that doesn't automatically make Johnny the executor of your estate. He's got to be approved and appointed by the court, okay? And one of the reasons that he may not be approved and appointed is if Johnny has a criminal history, okay? So, even though you list an executor in your will, it's got to be approved and appointed by the court, and then that executor can have the proper documentation, to begin settling the estate. And this basically means, collecting monies owed to persons who died. So they may be collecting wages. They may be paying outstanding bills, filing final income tax and estate tax returns, and if necessary, distributing the remaining property to the rightful heirs. Usually everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending upon the size of the estate. So as long as the executor does what needs to be done in a timely fashion and there's no family squabbles, you're looking at, like I said, a few months to a year. Now, some people may want to avoid the probate process, and we're going to take a look at why this might be the case, okay? Now, before we look at the reasons why you might want to avoid probate, we're just going to kind of review some of the positive aspects of probate, okay? For most states, there's usually little reason to avoid probate. The actual time and cost involved are pretty modest, and it just doesn't make sense to really plan around it. There are actually a couple of benefits from probate. Because the court supervises the process, you have some assurance that your wishes will be abided by, and if a family squabble should arise, the court can help settle that matter. Further, probate offers some protection against creditors. As part of the process, creditors are notified to make their claims against the estate in a timely manner, and if they don't, then it becomes much more difficult for them to make their claims later on. But, for some complex estates, probate can be more burdensome, taking up to 2 or more years. Okay, so for complex estates, the length of time that it takes to settle would be a negative in regards to probate. Because this could certainly tie up property that your family may need immediately, and it can increase the costs that can arise, such as executor fees, attorney fees, and insurance costs. Now, if you have real estate in more than one state, for example, if you own a summer home in Ohio and a winter home in Florida, your executor will have to file in each state where the property is located, and this is referred to as ancillary probate. Additionally, wills and any other documents submitted for probate become part of public record. Okay, so this may be undesirable if you and your family members have privacy concerns. So if any of these are issues for you, an estate plan can be designed to limit the assets that pass through probate, or to avoid probate altogether. So for example, I'm going to go back to the idea of listing beneficiaries on your various financial accounts. When you list beneficiaries on financial accounts, those assets and their distribution will supersede what is outlined in the will. Okay, so the will does not apply to those assets that you have listed beneficiaries on. That beneficiaries is and the transfer of funds to those beneficiaries is a very convenient way to make sure those assets get passed on. Transferring those assets to the beneficiaries can be done in a pretty timely manner. Really, once all the paperwork is processed and completed, I mean, it's really, just a matter of death certificates, transfer forms, maybe death claim forms, stuff like that. But that stuff gets processed, relatively quickly versus going through probate. So the will and probate is more of a catch-all for everything else that you didn't or couldn't list beneficiaries on. So the major ways property is passed outside of probate are by owning property jointly, which we talked about. So again, make sure you trust whoever you are owning property jointly with. It can be by ensuring that beneficiary designation forms are completed for those assets that allow them. Okay. Again, putting property in a trust is a way to avoid probate. Okay. And then also making gifts over your lifetime is a way to avoid probate. We're going to switch gears here a little bit, and we're going to talk about estate taxes. There are 3 types of federal taxes that may be imposed when property is transferred from one person to another, either during life or at death. And collectively, these 3 types are referred to as transfer taxes. And these taxes include the gift tax. They include estate tax. And then there's also what's called the generation skipping transfer tax. Okay. So one thing to keep in mind, that in Ohio, there is no estate tax in Ohio, unless property is being inherited from states outside of Ohio. And I think the ones that mainly apply are Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. Those states, I think, do have an estate tax. Okay, so don't hold me to that, but I think those states do. But if you want to transfer property, we're going to talk a little bit and focus on federal gift tax. So if you want to transfer property to another person during your life, then that transfer may be subject to a gift tax. Okay, and the reason there's a gift tax is to prevent individuals from avoiding the estate tax by giving all of their property away before they die. Okay. Now, the gift tax doesn't apply to every lifetime gift. So, for example, in 2021, you can give up to $15,000 to as many individuals as you want gift tax free under the annual gift tax exclusion. Okay. So, if you have a child and a child-in-law, son-in-law or daughter-in-law, you could give $15,000 to both your child and to both your daughter-in-law, okay, or son-in-law. And so, again, you can give $15,000 to as many individuals as you want to give it to. Also, each individual has a lifetime exclusion from all transfers. So that's gifts and your estates combined. And that amount is 11,700,000 in 2021. And that is the largest exclusion that has ever been allowed in the history of federal gift and estate tax. So when property is transferred at death, keep in mind, we're going to kind of go on to the next slide here, but that 11,700,000 doesn't apply to transfers made to spouses or charities, and it's excluded from all transfers. And also there is, how do I want to say this? That's for an individual. So if you're married, you can double that to whatever that math is, $23.4 million. Okay. And we're going to see that on the next slide. So this is called, this is a relatively new feature, which is a lifetime exclusion. And it's really important to consider for married couples. It's what is called, it is portable, which means any unused portion by the deceased spouse can be transferred to the surviving spouse. And again, together, that married couple can pass along $23,400,000 can be left to beneficiaries, as long as the spouse makes the proper election on the estate tax return. Okay. The third piece of the transfer tax system is what's called the generation skipping tax. Okay. Transfer tax. So in the world of estate planning, someone who is more than one generation below you, for example, a grandchild or great-grandchild, is referred to as a skip person. So if property is transferred either during life or at death to a skip person, then the transfer is subject to generation skipping transfer tax, which is imposed in addition to gift tax or estate tax. So the reason there's a generation skipping transfer tax is to prevent individuals from avoiding estate tax on the immediate skipped generation. And because the generation skipping transfer tax is a separate tax, you get a separate exemption. So the exemption for generation skipping transfer tax purposes is also $11,700,000 in 2021. So unlike the gift and estate tax exclusion, the GST is not portable. Okay, so it's not something that can be added to the limit for your spouse. So some key figures that are adjusted each year for inflation. You can see here basically how the exclusion and exemption amounts have changed, over time. The Tax Cuts and Jobs Act, signed into law in December of 2017, doubled the gift and estate tax exclusion amount and the GST tax exemption. The amounts currently are $11,700,000. Now, after 2025, they're scheduled to revert back to pre-2018 levels and basically get cut by 1/2. Okay, so if your estate is larger than the exclusion or the exemption, you may want to do some further estate planning to minimize the potential impacts of transfer taxes. We're going to go into a little bit more detail on lifetime gifting. Making gifts during one's life is a common estate planning strategy that can also serve to minimize transfer taxes. So in fact, transferring property to your heirs during your lifetime has certain advantages over waiting till you die. For one thing, when you make lifetime gifts, you have the satisfaction of seeing the recipient enjoy your gifts. Okay. For many people, gifting is used to minimize transfer taxes. And as I mentioned earlier, one way to do this is to take advantage of the annual gift tax exclusion. Again, this lets you give up to $15,000 to as many individuals as you want to, gift tax free. And there are several other gift tax exclusions and deductions that you might take advantage of. When you gift property that is expected to appreciate in value, you remove the future appreciation of your taxable estate. So there is a trade-off to lifetime gifting. Generally, if you give property during your life, your basis in the property for federal income tax purposes is carried over to the person who receives the gift. So if you give a $1 million home that you purchased for $50,000 to your brother, your $50,000 basis carries over to your brother also. Okay, so if he sells the house immediately, income tax would be due on that gain. Okay. However, that's if you're gifting the house to him. If you leave the property to your brother at death, then that cost basis gets stepped up. So that $50,000 would get stepped up to a $1 million cost basis, which would basically, if he sold the house right away for $1 million, and he would basically avoid, any type of federal capital gain tax or federal income tax there, okay, because there was a step up in cost basis, okay. This is using a home for an example, but it also applies to maybe individual stocks that you have held for a long period of time, land and other assets. So that step up in basis, can be really valuable when passing assets on. Okay. Now, remember that an annual gift tax exclusion lets you give $15,000 to as many individuals as you want, gift tax free. And if you and your spouse makes gifts together, you can double that amount and gift $30,000 to as many individuals as you want. Okay. If you're contributing to a child or a grandchild's college 529 plan, which is a type of tax deferred college savings plan, you can give $75,000 in 2021 to a 529 plan. So what you're basically doing is you're able to gift 5 years worth of gifts all at once, totaling $75,000. And if you and your spouse contribute together, you could put $150,000 into a 529 plan. Okay. So again, that's another effective way to be gifting money over. In addition, if there's no gift tax imposed on any amounts paid directly to an educational institution for an individual's tuition. So, this is talking about maybe prepaying tuition. okay, to a college or university. There's also no gift tax imposed on any amounts paid to directly to medical care providers for an individual's Medicare. So these are including payments for health insurance premiums. Okay, so these are all ways, that you're able to avoid gift tax. If you're not inclined to make outright gifts, one of the things that you might consider is using a trust. And we've already seen that a trust can play a role in planning for incapacity and in avoiding probate. In addition, you may want to use a trust as part of an overall strategy to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, or other beneficiaries. Certain trusts can be established to protect your assets from future creditors. And most importantly, trust can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain, again, a degree of control after property is placed in the trust, even after death. So this is where you start having what can be referred to as control from the grave, because any assets or any property that is put inside of a trust, that trust is its own separate entity. While you're living, you serve as the trustee, but once you pass away, that trust continues on, and then a surviving trustee would basically administer control over the trust. Okay, so again, a trust is its own separate entity. It's going to continue on after you pass away, and all the assets that are in the trust, would basically stay the same or be distributed according to the terms of the trust. So a trust is a legal entity where someone who is called the grantor arranges with another person who's called the trustee to hold property for the benefit of a third party who's called the beneficiary. Many cases, the grantor names the beneficiary and trustee and establishes the rule the trustee must follow in a document known as a trust agreement. A lot of times, the grantor and the trustee of a living trust are the same person. Okay, you're putting your own assets in a trust, and as the trustee, you are managing the trust or controlling the trust. So when you create a trust, you split the ownership of the trust property. Legal ownership goes to the trustee. Beneficial ownership goes to the beneficiary. That means that the trustee is legally responsible for managing the property according to the trust rules, and the beneficiary receives the financial benefits such as income, principal, use, and enjoyment of the trust property. Trust that you create while you're alive is referred to as a living trust. A trust that is created upon your death, for example, under the terms of your will is referred to as a testamentary trust. Okay, so if you have the right to change or end the trust anytime you want to, the trust is described as revocable. And if you cannot change or revoke the trust, then it is an irrevocable trust. Okay. So again, there's some benefits to using trust. I know a lot of attorneys, will certainly emphasize the benefits of a trust. I think in a lot of cases, trusts get utilized where a trust is not necessary. But you want to make sure that that's something that you talk through with your particular estate attorney. We're going to change gears here a little bit and talk about life insurance. Life insurance can play an important role in almost everyone's estate plan in one way or another. For example, if you have a small or a modest estate, life insurance could be used to create a larger estate. The life insurance proceeds would be the primary financial resources for your surviving family members until they're able to access the other financial resources. Okay, so again, life insurance, typically those claims get processed fairly quickly. They're a convenient, timely source of funds that could be used to take care of other needs, until some of the other accounts or other funds become available. So it can be used to provide liquidity for your estate. The life insurance proceeds will provide the cash your survivors need to pay final expenses, pay outstanding debts and taxes. For example, you may have physical assets such as a home, retirement plan, and some investments that you do not want to be liquidated, but rather left intact for your surviving spouse. So life insurance can play many roles, such as creating a bequest to a charity or providing funds for your child's college education. Now, you need to be aware that the general rule is that life insurance proceeds will be included in your estate for estate tax purposes. So if your total estate, including the proceeds from your life insurance, is equal to or less than 11,700,000, you really have no worries. But if your total estate is more than that, then some of those life insurance proceeds may have to go to pay estate tax. Okay. You might consider irrevocable life insurance trust. This is really more advanced than we're going to go into today. And so, that's something that if you have questions about, we can talk offline, but that's, like I said, that's really more of an advanced estate planning topic. So basically, as we wrap up, I want you to kind of take a moment and maybe ask yourself these questions. First of all, do you have a plan in place for incapacity? Do you have a will? Okay, do you have a valid will? If the answer to either of these questions is no, then there's really a sense of urgency that you need to address these issues as soon as possible. Ask yourself as well if transfer taxes are an issue for you. If you die today, would your total estate, including your home and life insurance, exceed the federal tax exclusion of $11,700,000? And even if you have an estate plan, does it reflect your current wishes and circumstances? Is it up to date? Okay. Are your beneficiaries up to date? Okay, so those are all things that you want to consider. I hope this information has been helpful for you. When you close out of the presentation, there is a survey that will pop up. It's just literally, I think, 3 or 4 questions. And so I just wanted to basically give you my contact information as well. There is a couple questions here. Let me see. Yeah, so someone had asked about a trust being a separate entity and how is it taxed every year while I'm alive? It will have a separate tax return to it. And so it will have, income. It will fall under its own income tax brackets and so forth. So it will be separate from your, we'll call it payroll income. Okay. So that's a good question. Trust does, I'm not a CPA, I'm not a tax professional, but my understanding is that, a trust would have and would file its own separate tax return. Okay. So good question. There's no further questions. Appreciate you attending. And again, if you just take a few minutes to complete the survey, we're going to wrap things up. Thank you.